Court rise. Honorable Justice Ekruche of the High Court of Warri presiding. Court now in session.
My Lord, suite number W48, 1968, the case of Idundun and others versus Okumagba. My Lord, plaintiffs are D.O. Idundun, Chief P.O. Awani, A.E. Hesse, C.A. Lori, J.D. Oburu, for themselves and on behalf of Ogitsi family of Okere Warri. Itsekiri communal land trustees, joined by order of court, and Erejua II, the Olu of Warri, for himself and on behalf of Itsekiri people, joined by order of court. Versus Daniel E. Okumagba, for himself and on behalf of Olodi, Igogbadu and Oki families of Idimisobo, Okere, Warri. My Lord, my name is O.N. Rewane. With me are Akporiaye, Ajuya, Agambi, and Popo. I appear for the plaintiff. My Lord, my name is Dr. Mudiaga Oje. With me are Akpodeye, Giwa Amu, Amrove, and Honoriobe. I appear for the defendant.
This version of the title Ogevoro is also confirmed by the evidence in the plaintiff's case, to which I referred when I was reviewing the evidence in the plaintiff's case.
As regards the name of the stream Ogogoro, shown on Exhibit 2 and 41, plaintiff's plan and defendant's plan respectively, the defendant said the name is a corrupt form of the word Ogogrobo, which means something that is straight and long. They said Obogoro and Oborogoro are Urobo words. As regards the meaning of Okere, the defendant said that when later settlers from Otokare came to meet the early settlers on defendant's land at Okere, they were struck by the paucity of the buildings they found at the settlement, and they said of the buildings, Ekere Ngovina, meaning these houses or huts can be counted, meaning that the huts and houses were few. The defendant said that from the Urobo expression, the word Ekere emerged, and Ekere was corrupted to Ekere, the name of the place. The defendant said that when their founding ancestors came to where they settled, the place Okere had no name, and that it was years after that the name Okere came to be given to the place. The defendants traced the genealogies of persons in the different families now known as Oki, Olodi, and Igobodu families. Of Idiboye, whom the plaintiff said Arukulei went to marry from Opare and lived with Arukulei as Arukulei's wife in Okere, the defendant said nobody by name Idiboye ever lived in Okere. In putting forward their case, the defendants testified as to customary court suits instituted against members of their families in respect of lands in the Okere area by members of Ogitsi family. They also testified as to other suits between them and members of the Ogitsi family, some in customary courts and others in the High Court.
My Lord, we usually refer to the Itsekiri section of Okere as Uduwi Hobo, and that the name of the quarters are Idimiakna, Odokporo, and Ogumbaite. However, in Ohobo section, the quarters are referred to as Idimuoki, Idimolodi, and Idimui Hogbadu, and that the said quarters are referred to as Idimohobo. My Lord, one cannot find the premises of an Hobo man in the Itsekiri section of Okere, with the exception of the premises of first plaintiff's father, who, all through his life, did not spend up to 1 week in his father's Hobo section. In the Ohobo section, you will not find any premises belonging to any Itsekiri person, and that Ologo, the son of Idama and the father of late Idundun, did not in fact marry Idundun's mother, because the mother of the late Idundun never came to live with Ologo in the Okere section. The rightful Oluraja of the Ogitsi family today is one Okeremporo and not the first plaintiff, because Okeremporo is not cooperating with the plaintiffs and therefore have not put him forward because he is opposed to this case.
According to the defendants, the rightful Olaraja of the Ogitsi family today is one Okremporo and not the first plaintiff, and they said Okremporo is not cooperating with the plaintiffs, and that the plaintiff have not put him forward because he is opposed to the case the plaintiffs are now making. The defendants said that the cause of quarrel between Okrenko and the plaintiffs is that the plaintiffs are putting forward the Olu of Warri as overlord of Okere. They said that the Okere people have always opposed the association of the Olu with the Okere land, and he, Okerenko, did so when the majority of the Okere people opposed the Olu when Ogbejo people instituted suit number W114856 Vide Exhibit 18. The defendants said that William Omatsone, now not living, was at one time a rival Olaraja. They said that he was not the rightful claimant to the post of Olaraja and that there was a rightful claimant, but that the Olu of Warri, for political reasons, he being Pro-Action Group and William Omatsone as well as Chief Ian Abego, plaintiff's sixth witness, being also Pro-Action Group, the Olu of Warri purported to constitute the post of Olaraja into a title, and he then conferred it on William Omatson. The defendant said the appointment was not recognized by the majority of the Ogitsi family, and that this event was about 1958 to 1960. They said that there has never been any chieftaincy title associated with the Ogitsi family of Okere. Learned counsel for the plaintiffs prefaced his arguments on the entire case by stating in summary form what, according to him, the plaintiff's case before this court is, and he was recorded verbatim as he spoke.
That the land in dispute, like all other Okere lands, is the property of the Ogitsi family, subject only to the overlordship of the Olu of Warri, in whom the radical title resides. That the defendants' families, and indeed the whole of the people of Idimisobos of Okere, are adopted members of the said Ogitsi family in accordance with the Itekiri customary law. That the whole of Okere land, including land in dispute, is the communal property of the said Ogitsi family, which means that it is communal to all the 5 2/4 of Okere, including Idimisobos. That the whole of Okere land, including the land in dispute, was and is still part of the kingdom of Warri, and therefore under the overlordship of the Olu. And that when Ekpen's war was over, his followers and his family were allowed by Ginua I to live on the said land according to Itekiri customary law. And ever since, first 5th plaintiffs have been assimilated into Itekiri community, and they recognize the overlordship of the Olu of Warri. That the 1st to 5th plaintiff's root of title is therefore based on permission of the Olu of Warri about 500 years ago.
The evidence in the whole case falls into 2 categories, namely traditional evidence and evidence of acts of ownership. The principles of law relating to the onus that lies on the plaintiffs in a case such as this have been stated over and over again in decided cases, and I will alter. Before proceeding to consider the merits of the evidence in the whole case, state the said principles. Counsel on either side in this case, in the way they put forward their submissions, are largely agreed on the principles. The principles are as follows. The onus is on plaintiffs seeking declaration of title to land to prove their case, and they must succeed on the strength of their own case and not weakness of the case of the defense.
See the cases. Rufai versus Ricketts, 2 WK 95 at 97. Kodilonyo Odu, 2 WK 336, pages 337 to 338.
The rule that in establishing their case, plaintiffs must succeed on the strength of their own case and not on the weakness of the defendant's case does not apply where the defendant's case in itself supports that of the plaintiffs and contains evidence on which the plaintiffs are entitled to rely. See Akinala and another verses, Oluwa and 2 others. For the plaintiffs to succeed on traditional evidence, the said traditional evidence must be reliable and convincing. See the case of Akuru versus the Olubadan in council. In a claim for a decree of declaration of title, the onus is on the plaintiffs to prove acts of ownership extending over a sufficient length of time, numerous and positive enough to warrant the inference that the plaintiffs were the exclusive owners. If the evidence of tradition is conclusive, the case must rest on question of fact. See the case of Adere versus Adedere, 1996. Where there is a conflict of traditional history which has been handed down by word of mouth, the matter has to be approached and dealt with in the manner stated in the case of Koju versus Bonsi and another. The case cited above is a decision of the Privy Council, where that board in its advice said inter alia as follows. The dispute was all as to traditional history which had been handed down from the word of mouth from their forefathers. In this regard, it must be recognized that in the course of transition from generation to generation, mistakes may occur without any dishonest motives whatever. Witnesses of the utmost veracity may speak honestly but erroneously as to what took place 100 years ago. Where there is a conflict of traditional history, one side or the other must be mistaken, yet both may be honest in their belief. In such a case, demeanor is little guide to the truth. The best way is to test the traditional history by reference to the fact in recent years as established by evidence, and by seeing which of the 2 competing histories is the more probable. Considering first the traditional evidence in the case, my view of that aspect of the evidence in plaintiff's case whereby plaintiffs have sought to establish that the land in dispute and even also Okere village were part of the kingdom founded by Ginua I, and the evidence that Ogitsi owned the whole of Okere land, including the land in dispute in this case, is unconvincing. The plaintiffs say that Ginua I founded a kingdom and that before Ekpen came to Okere, the area of Okere was or would be part of that kingdom. There is no evidence of the extent or the area covered by that kingdom, nor is there evidence going to show any act or acts in history which made the area part of the kingdom founded by Ginua I before Ekpen came there. There is no evidence that either Jinua I himself or any representative of Jinua I ever set foot on Okere soil before Ekpen got there. The evidence in plaintiff's case is that when Ekpen got to the area now known as Okere, he met no one there, and plaintiff's evidence does not suggest that anyone had set foot there before Ekpen got there.